All right, so hello and welcome students, myself Kumar Saurabh. Today I am present in front of you with a passage for your critical reasoning preparation and practice as well. So basically, of course, let me first tell you what are the benefits which you are going to get if you solve a question like this. So first of all, you'll be getting acquainted with the kind of questions which are there in your law entrance examination as far as the critical reasoning section is concerned. And then in the course of our discussion, we'll be also dealing with the basic concepts of the different questions as well. So without wasting any more time, let's get started with the first paragraph that is at hand for today. All right. So the Supreme Court on Friday quite rightly stayed an Andhra Pradesh High Court order that sought to convene a judicial inquiry into whether there is a constitutional breakdown in YS Jagan Mohan Reddy led government in the state. सुप्रीम कोर्ट ने आंध्र प्रदेश का जो ऑर्डर था कि एक जुडिशियल इंक्वायरी की जाए कि वेदर देयर इज अ कॉन्स्टिट्यूशनल ब्रेकडाउन इन द स्टेट ऑफ आंध्र प्रदेश, उस पे स्टे लगा दिया है और सही लगाया है, ऐसा ऑथर का कहना है. देन फिर ये बोला जा रहा है द टॉप कोर्ट्स इंटरवेंशन. सो बेसिकली अब आगे के लाइंस आप पढ़ोगे ना तो आपको यहाँ पे ये पता चलेगा कि ऑथर ने ये कहा कि अगर ऐसा स्टेप सुप्रीम कोर्ट नहीं लेती तो शायद प्रेसिडेंट रूल लगाने की नौबत आ सकती थी. साथ ही साथ ये बोला गया कि जब भी कॉन्स्टिट्यूशनल मशीनरी के फेलियर के बारे में डिस्कशन करना होता है या कुछ जानना होता है, कुछ देखना होता है, तो वी नीड टू रेफर टू द आर्टिकल 356 ऑफ द इंडियन कॉन्स्टिट्यूशन. वहां जाके आपको ये पता चलेगा कि ये काम एग्जीक्यूटिव का होता है, जुडिशरी का नहीं होता है. ठीक है. सो बेसिकली द ऑथर ऑल्सो सेड कि इट इज अ क्लासिक केस ऑफ जुडिशियल ओवररीच in the part of Andhra Pradesh High Court, and the stay order which the Supreme Court gave is a right one. ये बात बताई गई हमें. Then in the SR Bomai case, a 9-member bench of the Supreme Court construed the scope of Article 356, which also allows the imposition of President's rule in the state. अब SR बोमाई केस के बारे में बताया गया. अब ये कहा जा रहा है कि इसमें हमें ये भी पता चलता है कि प्रेसिडेंट रूल जो है उसका इंपोजिशन भी एक स्टेप हो सकता है इन केस देयर इज अ कॉन्स्टिट्यूशनल फेलियर द मशीनरी ऑफ if there is a question of constitutional breakdown. Okay, then with stringent conditions for valid exercise of that power by the president after being presented with a proclamation by the Union Council of Ministers. Then when you keep on reading the passage, you'll get to know the procedure through which this thing is done as laid in the case of SR Bomai. Okay. Then these included ascertaining whether objective conditions exist which render it impossible to carry out governance in the state where the proclamation has been made and the process has to be approved by both houses of parliament before consideration for judicial review. तो ये पूरा का पूरा प्रोसीजर यहाँ पे बता दिया गया है through the case of SR Bomai. All right. Then the Supreme Court's order comes in the wake of incidents pointing to a tussle between the judiciary and the elected government in Andhra Pradesh. अब ये जो टसल वाली बात है ये मीडिया में काफी टाइम तक रहा भी था, काफी sought after और काफी पॉपुलर इशू ये हुआ भी था. Chief Minister Reddy had in an unprecedented letter to the CJI even as the CJI complained about the alleged hostile attitude of the High Court against him and his government. Chief Minister जो हैं रेड्डी साहब वो ये बात ऑन रिकॉर्ड भी बोल चुके हैं कि जो जुडिशरी है, जो हाई कोर्ट है, वो हॉस्टाइल है मेरे गवर्नमेंट को लेके. देन दिस वाज इवन एज द हाई कोर्ट ऑर्डर्ड अ CBI probe into what it termed was a social media campaign against the judges. Self-explanatory. The onus is now on the Supreme Court to put an end to the unseemly tussle between the judiciary and the government in the state. Again, self-explanatory in nature. And then the last line is, a clear nullification of the High Court order will also ensure that such legal adventures impinging upon the separation of power in the state are not repeated. तो अब एंड में ऑथर ये कह दिया, ये बता रहा है हमें कि ऐसा ऑर्डर अगर कोई कोर्ट देता है, जैसा कि आंध्र प्रदेश हाई कोर्ट ने दिया, तो उसका नलिफिकेशन ही एक क्लियर सॉल्यूशन है, ताकि जो सेपरेशन ऑफ पावर का डॉक्ट्रिन है वो खतरे में ना आए. So, based on this passage, based on the discussion that we just had, let's start with the first question. Which of the following gives the best conclusion to the passage? Which of the following gives the best conclusion to the passage? Here, the right answer is going to be D, which says, Andhra Pradesh High Court indulged in the executive functioning of the state, which is outside its scope. Clearly, यहाँ पे mentioned भी था passage में. Then next question, which of the following cannot be said to be an inference for the passage? Cannot be said. Can be said नहीं कह रहा है, cannot be पूछ रहा है हमारे से. Then here the right answer is going to be B. SR Bomai case is in violation of the basic fundamentals of the doctrine of separation of power. If at all it maintains the doctrine of separation of power. So it is not an inference which we can extract out of the passage. Next question, which of the following is not an assumption behind the statement, whether in circumstances prevailing in the state of Andhra Pradesh, the court can record a finding that there is a constitutional breakdown in the state or not? Again, the question is asking us which of the following is not an assumption based on which this statement can be said. So, the right answer here is going to be B, which says the conflict within the state of Andhra Pradesh has given rise to a situation of constitutional breakdown. No, it is not an assumption based on which we can say this statement. Alright, basically what an assumption is? An assumption is an unstated premise based on which the author gives his or her argument. Moving on, the next question is, what is the central idea around which the passage revolves? Central idea around which the passage revolves. Straightforward right answer here is going to be D, which says judicial inquiry into the executive function of the state must be curbed. इसी बात पे कंटेंशन था ना कि अगर कोई काम हाई कोर्ट करना चाह रहे किसी भी स्टेट का और वो उसके पावर के अंदर है, तो आप नहीं कुछ कह सकते उसके बारे में, आप कोई ऑब्जेक्शन नहीं दे सकते. बट कोई ऐसा काम अगर कोर्ट करना चाहे जो उसके एम्बिट के बाहर आता है, अगर वो एग्जीक्यूटिव फंक्शन में इंटरफेयर करने की कोशिश करे, तो दैट इज नॉट correct as far as the doctrine of separation of power is concerned. So that is why D is the correct answer here. Last question of this passage, which of the following is in contrast with the author's argument? Okay, here the right answer is going to be D, which says the executive actors in a state can complain to the Supreme Court about the judicial wrongdoings being faced by them in a particular state. So it is in contrast with the author's argument presented in the paragraph. So this marks the end of this paragraph and all the questions have been solved. I hope you guys understood the crux of the passage and you were able to solve the questions related to it as well. So on this point, I'll conclude for today. Thank you so much for watching. Keep on watching more videos on our official CLAT Gurukul channel. Till then, take very good care of yourself. Thank you.